After the plea deal, the case did not become private again because the public had already learned how much of the story existed as recordings and paperwork. People wanted the missing trial, and when a trial does not happen, people look for the next closest thing. They look for the file. That pressure produced a turning point on November 21st, 2018, when the Weld County District's Attorney's Office released more than 2,000 pages of investigative material in response to a Colorado Criminal Justice Records request. It was a flood of reports, summaries, and digital fragments that transformed the case from a courtroom outcome into a publicly readable archive. For many people, the archive felt like access to the truth. For the surviving families, it felt like the loss of control over privacy that had already been violated by violence. Because those pages did not only describe what investigators did, they also contained pieces of a real family's internal life, including texts, worries, and conversations that were never meant to be consumed by strangers. This is the moment where the case became two stories at once. It remained a closed legal matter because guilt was admitted and the sentence was permanent. It also became an open cultural file because the documents gave people something to keep reading, posting, and debating. Once that happens, the story does not simply continue. It multiplies. One group reads the documents to understand how investigations work and how lies collapse under verification. Another group reads the documents to find a new suspect because a new suspect feels like a deeper explanation. Another group reads the documents to judge the marriage as if judging the marriage could explain the murders. Another group reads the documents to feed a sense of certainty because certainty feels safer than the idea that a normal life can break in ways that are not predictable. When a case becomes an archive, every sentence can be converted into content. A paragraph can become a screenshot. A screenshot can become a headline. A headline can become a theory. A theory can become a community. At that point, the legal system is finished, but the social system is just getting started. The legal system also has its own limits, and those limits become visible when the public demand shifts from general documents to the most sensitive records. In the Watts case, that pressure appeared early around the autopsy reports. The coroner's office received multiple requests for autopsy reports, and the matter moved into court, where a judge issued an order keeping the autopsy reports confidential until a hearing could determine whether public disclosure would do substantial injury to the public interest. That court fight is important because it shows the boundary the system tries to draw. Transparency matters. Accountability matters, but so does dignity for the dead and trauma for the living. In a case that is already being consumed as a spectacle, an autopsy report can become something more than a medical document. It can become a weapon in the hands of conspiracy communities, and it can become a source of graphic exploitation that does not add understanding, only damage. So, the system tried to slow disclosure in that specific category, even as other parts of the file were already moving into the open through records requests. Then, the case created another kind of pressure. A pressure that high-profile cases always generate. Pre-trial publicity. Even when evidence is strong, even when guilt seems obvious, the defense has the right to demand fair process. And in late August of 2018, defense filings complained about publicity and alleged leaks, arguing that details were appearing in media before the defense had received formal discovery. That is not an argument about innocence. It is an argument about control of narrative and the integrity of procedure. Because if a case goes to trial, the state does not want a jury pool poisoned by leaks. and the defense does not want the state's version of events hardened into public certainty before the defense can even see the evidence. In the Watts case, those concerns were real, but they were also overtaken by the speed of the legal ending. The guilty plea eliminated the trial. Once the trial disappeared, the center of gravity shifted away from the courtroom and deeper into the archive. That is why the Weld County District Attorney's Office eventually published formal instructions for requesting access to Watts' case materials. It is rare for a local prosecutor's office to build a public-facing access pipeline for a single homicide case. But this case forced that kind of adaptation. The case was no longer only a prosecution. It was a permanent public record event with ongoing demand that had to be managed through forms, processing, and controlled access. Then, the archive expanded again, and this time, it did not merely add context. It reactivated the case worldwide. On March 7th, 2019, audio recordings and documents tied to the February 18th, 2019 prison interview were released publicly. The release had a different feel from the November document dump. The November release was volume. The March release was voice. It placed the convicted killer back into the narrative, speaking again, describing again, offering again a version of events that the public could not stop trying to map. This is where the cultural life of the case became even more entrenched. A written report can be read and debated, but audio changes how people experience a story. Audio can feel intimate. Audio can feel like confession even when it is curated. Audio can create the illusion that hearing equals knowing. For investigators, the February prison interview had a practical purpose. They had already secured the plea and the sentence. They were not trying to prove guilt. They were trying to clarify, document, and close gaps that a trial would have addressed, because a plea ends the legal fight quickly, but it can leave unanswered questions about sequence, method, and motive. For the public, the March release felt like the missing chapter that the plea prevented from being aired in open court. It became the closest thing to a trial narrative that the public would ever receive, and it restarted the entire case as a cultural event. It also created a deeper problem. When a murderer's voice is released, the murderer is given a form of presence. Presence creates attention. Attention can become the last currency a convicted killer has. So, the public faced a choice, even if it did not recognize the choice in the moment. The public could treat the release as documentation and learn from it with discipline, or the public could treat it as content and reward it with endless circulation commentary and speculation. In the years that followed, both things happened. The disciplined reading of the archive showed a case that moved fast because modern investigations are built on verification. Surveillance footage anchored movements. Digital trails anchored contact. Hard, because this is so weirdy-eyed, the bedia. The DOS of wonder in HU part Folning's writings and, well, Prowichto. And so, well, a teen born of the forest saw Trangers ride that so wonder. Witness behavior anchored urgency, including the friend who raised alarm quickly and did not treat silence as normal. That is the mechanical truth of the case. But the undisciplined reading of the archive produced a different phenomenon. It produced communities that treated every gap as proof of conspiracy and treated every human reaction as coded guilt. It produced suspicion that expanded beyond the evidence. It produced harassment of people connected to the case. It produced a culture where certainty is rewarded, even when certainty is built on inference rather than proof. That is why the record fights matter. That is why the court order around autopsy reports matters. That is why formal access processes matter. Because a case like this does not stay solved in the public mind simply because the court solved it. The court solved guilt. The court solved punishment. The court did not solve the public hunger for a why that feels proportional. A plea deal can remove risk from the legal system, but it can also create vacuum in the public imagination. When there is no trial, there is no single moment where evidence is presented in order, tested in court, and then sealed into a verdict that feels like a complete narrative. Instead, people get the archive, and an archive can be consumed in any order. People start with the porch interview and then read documents. People start with documents and then listen to audio. People start with the documentary and then go hunting for files. Each path creates a different emotional experience, and emotional experience can harden into belief, even when belief is not backed by independent proof. This is the final transformation of the Watts case. It began as a missing family report. It became a rapid criminal investigation with a confession and recovery. It ended in court with a guilty plea and life without parole. Then it became a permanent archive, expanded through releases in November 2018 and March 2019, and kept alive through the modern machinery of attention. The archive makes the case accessible. The archive also makes the case renewable. Uia prehergenso pot, be code. This is look more teen diwardi. Within, I hint a self pretolde stuck to the say, wide some her 1,000 mice. So, the timing is so canding and was all, it was so plating the man, but the timed v paybiabio so can way. What I was but what did he trestin, like shipping to Mike, lady tune that word bore, menche to get 'em so canned. Renewable means the victims can be forced back into the spotlight again and again. Renewable means the killer's image and voice can keep circulating, even though the legal system already did the only thing it can do to remove him from the world. So, the hardest truth about the public phase of this case is not about evidence. It is about incentives. The law incentivizes closure and proof. The internet incentivizes engagement and repetition. A case like this will never truly end inside culture unless the audience chooses to treat the archive like a record, not like entertainment. Because the archive will always be there. The question is, what people choose to do with it. After the plea deal, the case stopped moving forward in court, but it kept moving outward through the public record, and the people inside the system had to decide what kind of truth would be released and what kind of truth would be restricted. That decision did not begin after sentencing. It began earlier, while the case was still moving toward trial, when prosecutors recognized that this file would not stay inside the usual boundaries of a local homicide. In Colorado, autopsy reports are generally treated as public records, but the law also allows a court to restrict disclosure if releasing them would cause substantial injury to the public interest. In the Watts case, that legal phrase became a real line drawn in real time. Prosecutors asked the judge to keep the autopsy report sealed while the case was pending, arguing that disclosure could taint witnesses, distort testimony, and make it harder to seat an impartial jury in a case already saturated with national attention. The request was not presented as secrecy for secrecy's sake. It was presented as protection for procedure. A trial depends on witnesses speaking under oath without being influenced by graphic details circulating in public before testimony. A trial depends on jurors arriving without having consumed the case as content for months. A trial depends on a controlled flow of evidence. That is the logic prosecutors emphasized. And for a period, the autopsy reports remained under seal, even as the rest of the case became more visible through other releases. This created a contradiction that never fully resolves in a notorious case. The public demands transparency. The justice system demands order. The families demand dignity. And the internet demands access to whatever hurts the most. Those demands do not align. Then the case ended without a trial? And the logic shifted again. Once a guilty plea erased the jury trial, the argument about tainting jurors lost much of its force. But the argument about harm did not disappear. Because the harm was never only procedural. The harm was also human. Graphic medical detail can become exploitation. It can become a scoreboard for strangers. It can become a weapon for conspiracy communities that will twist anything into a narrative. So, even in a solved case, the system still has to weigh what disclosure accomplishes and what disclosure destroys. At the same time, other parts of the archive were already being released in ways that fed the public's hunger for a missing trial. On November 21st, 2018, more than 2,000 pages of investigative documents were released through the Weld County District Attorney's Office in response to a Colorado Criminal Justice Records request. That release was not experienced as routine transparency. It was experienced as revelation. It turned the case into a downloadable structure where the public could move through interviews, reports, and private messages and build its own narrative in any order it wanted. And when people build narratives in any order they want, the story stops having one shape. It starts generating multiple competing shapes. Some people treated the document release as a lesson in how verification collapses deception. They focused on timestamps, surveillance, and the speed of modern investigation. Other people treated the document release as a prompt for suspicion. They searched for gaps and treated those gaps as proof of hidden players. Because gaps feel like evidence when a person is determined to believe something larger is operating behind the scenes. That is the psychological effect of a plea. The law closes the case quickly. The public keeps searching for meaning. And it searches inside the archive because the courtroom never performed that meaning in front of a jury. Once the case became an archive, the district attorney's office had to manage demand as an operational problem, not just a public relations problem. A formal process was published for requesting access to released Watts case materials because the flow of requests was continuous, and because an open file of this size becomes unmanageable without rules. Then, the archive expanded again in a different way, because paperwork creates distance, but audio creates proximity. On March 7th, 2019, the Colorado Bureau of Investigation released a redacted report documenting a follow-up prison interview conducted on February 18th, along with related audio and documents. This was the opposite of a courtroom performance. It was a structured, official conversation conducted after sentencing, when the legal outcome could not be negotiated and could not be softened. It delivered detail that a trial would have brought out, but it delivered it without the cleansing discipline of cross-examination and without the single narrative arc a courtroom imposes. So it reactivated the case globally. not as a legal event, but as a cultural event. And that reactivation created the modern afterlife of the Watts case. The court ended the prosecution. The archive kept generating attention. The record releases created waves. Each wave created new commentary. Each wave pulled survivors back into the same week again, only now through the voices and screens of strangers. This is why the case feels like it never ends. A trial would have ended with a verdict and a sealed narrative. A plea ended with a sentence and an open archive. The open archive is not neutral. It is a machine. It rewards attention. It rewards repetition. It rewards the most graphic detail. It rewards the killer's voice when the killer's voice should have died at sentencing. And it keeps testing the same boundary over and over. How much truth does the public need to know? And how much truth does the public simply want to consume? Because the moment truth becomes something people consume for stimulation, the case stops being about justice. It becomes about appetite. And in the Watts case, the appetite never stopped asking for the next file. By the fall of 2018, the Watts case had already become more than a prosecution. It had become a public event that the court could not fully contain. That is why the fight over records began early, before any plea, before any sentencing, and before the public even understood how long this story would remain alive. In Colorado, autopsy reports are generally treated as public records, but the law also gives the official custodian a way to ask a judge for permission to restrict disclosure if releasing the record would cause substantial injury to the public interest. That phrase sounds abstract until a case like this forces the system to define it in real time. In mid-September 2018, prosecutors asked the court to restrict disclosure of the autopsy reports. They argued that the observations and findings would be critical evidence at trial. They argued that releasing them before trial could taint witnesses who had not yet been interviewed and could impact future jurors in a case already saturated with attention. A judge issued an order that treated the reports as confidential at that stage, required the reports to be provided under seal to the court and to the defense, and set a schedule for filings and a future written order after in-camera review. The order made something else clear. At that moment, the court said it was not aware of any member of the public who had even made a public records request for the autopsy reports yet. The court was drawing a boundary before the crowd reached the door. That boundary mattered because it exposed the competing forces that would shape the rest of this case. The public wants transparency. The justice system wants procedure that will survive scrutiny. The families want dignity for the dead and peace for the living. And the internet wants the most extreme detail as fast as it can get it. Those forces do not align. By early October 2018, the autopsy reports were complete and in the possession of prosecutors, but they remained sealed pending a hearing that had not yet been scheduled. The system was still acting as if the case would go to trial. A trial requires a controlled flow of evidence. A trial requires witnesses whose testimony is not shaped by graphic details circulating for months. A trial requires jurors who arrive as jurors, not as a pre-built audience. Then the story changed faster than anyone expected. On November 6th, 2018, Chris Watts pleaded guilty. On November 19th, 2018, he was sentenced to multiple life sentences without the possibility of parole. The moment the plea erased the jury trial, the logic of protecting jurors lost much of its force. But the logic of harm did not disappear. Because harm is not only about procedure. Harm is also about what happens to a family when the most intimate and brutal facts of their loss become a form of public consumption. Soon after sentencing, authorities released the autopsy reports. The reports confirmed the cause of death in a way that ended any remaining ambiguity about method. For the public, this release felt like another revelation. For the families, it was another turning of the knife, because the world was now reading about their daughter and grandchildren in clinical terms, as if the language of medicine could make the reality easier to hold. This is where the Watts case became a model for the modern pressure placed on the justice system. A local homicide becomes a national obsession. National obsession becomes records requests. Records requests become document dumps. Document dumps become content. Content becomes commentary. Commentary becomes a permanent loop that reopens the same week again and again. The autopsy reports were only one part of that loop, but they showed the shape of the problem. The public believes access equals understanding, but access can also equal exploitation. In a case this famous, the rawest documents do not always educate. Sometimes they only feed appetite. And once appetite is fed, it grows. That appetite pushed the case deeper into an archive culture, where the public does not wait for a courtroom to tell a story in order. The public assembles its own story from files. On November 21st, 2018, more than 2,000 pages of investigative documents were released through the Weld County District Attorney's Office in response to a Colorado criminal justice records request. That release did what a trial would have done in one structured arc, but it did it in a scattered way, through pages, screenshots, and copied excerpts moving across the internet. People read texts as if they were confession. People read interview summaries as if they were verdict. People treated timeline notes as if they were motive. And because the plea deal removed the trial, the archive became the main stage. The district attorney's office later published a formal process for requesting access to released Watts case materials because the demand did not fade. A local prosecutor's office had to build an intake pipeline for a single case. That is not normal. That is what notoriety does. This is also where the case begins to harm in a different way. A solved case can keep injuring the living because the archive makes it renewable. A new person discovers the case through a documentary. They search for the documents. They find the porch interview. They find the body camera. They find the interrogation. They find the text. They feel close to the story, and that closeness creates confidence. Then confidence becomes judgment. Judgment becomes theories. Theories become communities. Communities become harassment because the internet rewards certainty, and certainty is easiest when it has a target. The legal system cannot stop that machine. The legal system can only decide what it releases and when. But even those decisions have consequences, because withholding creates suspicion and releasing creates circulation. That is the double bind. If officials release less, people assume the truth is hidden. If officials release more, people treat tragedy like a file they have the right to possess. By early 2019, the case was already in its archive phase, and the archive was still expanding. Investigators returned to the case in February 2019 for a follow-up interview with Chris Watts at the Wisconsin prison. This was not a negotiation. This was not a trial prep. This was a record closure interview. It was conducted after sentencing, when his legal future was already fixed. According to reporting tied to the release, the interview included a Colorado Bureau of Investigation agent, a Federal Bureau of Investigation agent, and a Frederick Police Department detective. That detail matters because it shows how seriously the system treated the record even after the case was legally finished. When a case becomes this famous, the record becomes part of public history. The public will keep asking for a why, and if the system does not close the gaps, other people will rush in to fill them with speculation. So investigators tried to close the gaps. Then, on March 7th, 2019, audio recordings and documents connected to that February prison interview were released publicly. That release created a new wave. It created a new round of headlines. It created a new round of rewatching. It created a new round of people returning to the porch interview and hearing it differently, not as uncertainty, but as performance. This is one of the most unsettling truths about the case's afterlife. The punishment was final, but the narrative was not. Every new release became another episode. Every episode pulled the story forward into the present again, even though the crime happened in August 2018. That is the real power of archives in the digital era. Archives make time collapse. A clip filmed on a porch in Frederick can be watched years later by someone who feels as if it is happening now. A text message written in private can be treated as public evidence forever. A court order written for procedure can be reinterpreted as a conspiracy. A medical report written to document death can become a piece of content, and content never rests. That is why the early fight over the autopsy reports matters. It was not only about evidence. It was about the system trying to decide what it owed the public and what it owed the dead. It was about whether the phrase substantial injury to the public interest could mean anything. In a world where public interest is often indistinguishable from public appetite, the Watts case shows that this tension does not go away when a case is solved. It grows after the plea because the plea creates a vacuum. A trial is a structured explanation. A plea is a fast ending. A fast ending leaves people hungry for the missing middle, so they turn to the archive. The archive feeds them. The feed never stops. The system can lock a man behind concrete and steel. The system cannot lock the story. The story remains accessible as long as records exist. And records exist as long as the public keeps requesting them. That is the reason the Watts case still feels present. Not because guilt is unclear, not because the sentence is unstable, because the archive made the tragedy renewable. The court ended the legal narrative. The archive created a cultural narrative that can restart at any moment. And once a story can restart forever, the only real end is the end the audience chooses. The audience can choose discipline. The audience can choose restraint. The audience can choose to treat the record like a warning instead of a spectacle. Or the audience can keep feeding the machine. One document, one clip, one file at a time. In the Watts case, the machine kept being fed. That is why the story never truly leaves the present. Even before the guilty plea, the legal system could see what was coming. This was not going to be a normal homicide case that lived quietly inside a courthouse. It was going to be a case that the public tried to consume in full, page by page, detail by detail, until nothing felt private anymore. That pressure showed up early around one of the most sensitive categories of records in any death investigation: the autopsy reports. In Colorado, autopsy reports are generally treated as public records, which means they can be requested. But the law also recognizes that there are moments when disclosure can create harm that outweighs the value of immediate access. In September of 2018, prosecutors asked the court to block the release of the autopsy reports while the case was still headed toward trial. Their reasoning was procedural. They argued that the findings would be critical evidence. They argued that releasing them early could influence witnesses. They argued that a case already saturated with national attention could be damaged further if graphic medical detail became public before a jury was even chosen. At the time, that request was part of a larger effort to keep the case inside the rules of court instead of letting it become a public spectacle that wrote its own verdict online. But in October of 2018, the court drew a line that mattered. A judge denied the prosecutor's request, ruling that prosecutors did not have standing to seek the sealing of autopsy reports, and that the request had to come from the custodian of the records. In this case, that meant the county coroner. That decision was not about whether the public should eventually see the reports. It was about process. Who has the authority to ask a court to restrict access? What makes this important is what happened next. Within days, the coroner filed a petition asking the court to keep the autopsy reports sealed. And that move revealed the deeper truth. This was not only a legal dispute, it was a collision between transparency and trauma. Media organizations were seeking the reports. Public interest was intense, and the family at the center of the case had no way to step away from the demand because a public records request does not care how broken a family feels. While that fight was unfolding, the criminal case continued moving forward. Evidence was being organized. The defense was making filings. The court calendar was filling. And then the case ended abruptly. On November 6th, 2018, Christopher Watts pleaded guilty. On November 19th, 2018, he was sentenced to life in prison without the possibility of parole. That sentencing moment did two things at once. It locked the legal outcome permanently, and it removed the trial that would have controlled how evidence and details entered the public domain. After the plea and sentencing, the autopsy reports were released. The reports confirmed in official medical terms that all three victims died of asphyxiation. Shanann Watts was killed by strangulation. Bella and Celeste were killed by smothering. Those facts were not new to investigators, and the public already understood the broad shape of what had happened. But the release still landed like a shock, because a court record and a news report can hold details in a way the human mind cannot easily look away from. This is the moment where a case crosses another threshold. A case stops being a crime that people discuss. It becomes a set of documents that people possess. And once people possess the documents, they start using them. Some people use them to understand. Some people use them to sensationalize. Some people use them to create theories that cannot be proven. Some people use them to push blame outward, because outward blame feels safer than the idea that one person can choose annihilation. This is why the autopsy fight mattered. Not because the reports were the most important proof in the case. The confession and recoveries already secured the legal outcome. The fight mattered because it showed the system trying to decide whether public access would lead to public understanding or public exploitation. And in a case like this, the answer is never clean. The public says it wants truth. The internet often wants content. The victims' families want dignity and quiet. The justice system wants a process that survives scrutiny. Those goals do not naturally align. Then the archive expanded again, not through medical records, but through investigative volume. On November 21st, 2018, the Weld County District Attorney's Office released more than 2,000 pages of investigative documents in response to a Colorado criminal justice records request. This is where the case truly entered its long afterlife. Those pages did not feel like routine transparency. They felt like a substitute for a trial. They contained interview summaries, investigative notes, and private messages that showed the final weeks of a marriage collapsing under secrecy. They showed the difference between what was happening inside the home and what the world saw on the outside. They turned private pain into a public timeline. For some people, the release was a lesson in how modern investigations work, how timelines are built, how phone data and witness statements intersect, how a person's story collapses when it is compared to objective records. For other people, the release became a factory for speculation because documents do not arrive in a single narrative arc. A trial gives order. An archive gives access. Access lets people build their own order. And the order they build is often shaped by what they want to believe. This is where the case became renewable. A new audience discovers the story through a documentary or a clip. That audience then goes looking for the files. They find the files. They start reading messages that were never written for them. They start treating marital conflict like a moral trial. They start treating ordinary human reactions like coded proof. And because the archive is permanent, the cycle restarts again and again. The district attorney's office had to respond to the scale of that demand. A local office is not designed to handle global traffic for a single homicide case. So a formal process was created to streamline requests for Watt's case materials. The office even stated that it was not the custodian of records for the February 2019 prison interview and directed requesters to the Colorado Bureau of Investigation for that category of material. This is what notoriety forces. It forces institutions to build a public access pipeline for one case, as if the case were a permanent public exhibit. But the story did not end with paperwork. Paper creates distance. Audio creates proximity. In February of 2019, investigators traveled to the Wisconsin prison to conduct a follow-up interview with Watts. This interview happened after sentencing, when he had nothing left to negotiate. The purpose was not to prove guilt. The purpose was to clarify and document his account after the case had ended in court. In March of 2019, the redacted report of that interview was released publicly. And audio connected to it circulated. That release had a specific effect. It brought the killer's voice back into the story. A written document can be read as information. A voice can be experienced as presence. And in a case like this, presence is dangerous because attention becomes a form of currency for someone who has nothing else left. This is one of the most unsettling truths about the Watts case. The system did the one thing it can do to remove a person from the world. It locked him away permanently. But the system cannot lock away the record. And once the record exists in public, the story can be replayed forever. That replay has consequences. It keeps the victims from resting quietly in the public mind, because new audiences keep encountering their names as if the tragedy just happened. It keeps survivors under pressure, because every new wave of attention invites new judgment from strangers who were never there. It keeps creating a market for dramatization, analysis, and commentary, because the internet rewards engagement more than restraint. And it keeps testing the same boundary that the autopsy fight exposed. How much access is education, and how much access is appetite? The Watts case became a model for this conflict. The legal outcome was fixed. The cultural outcome remained unstable, constantly reshaped by new waves of content and renewed attention. That is why the records disputes matter. That is why the release dates matter. They are not just administrative details. They are the moments when the story moved from a courtroom into the public bloodstream. In court, a case ends with a sentence. Online, a case ends only when people stop reopening it. And in the Watts case, the archive made reopening effortless. A form can be submitted, a file can be downloaded, a clip can be replayed, a paragraph can be turned into a screenshot can be turned into an accusation. And once accusations circulate, the case generates new harm, even after justice has been done. So, the autopsy dispute was never only about whether the public would see medical findings. It was about whether the justice system could still protect dignity in a world that treats tragedy as consumable. The system tried to manage the flow. A judge drew procedural boundaries. A coroner sought sealing. A plea erased the trial. Then, the documents poured out anyway, because public demand does not fade when a story becomes famous. It grows. And that is the final transformation. A crime becomes a case. A case becomes a sentence. A sentence becomes an archive. And an archive becomes a machine that can keep the story alive long after the victims are gone, and long after the court has done everything it can do. By the time the investigation records started circulating, the case was no longer only a criminal file. It was becoming an industry. Once the documents were released, people stopped waiting for the justice system to explain the story in order. They began building their own versions of the story from fragments. That is how a tragedy turns into content. First, the case becomes a stream of records. Then, the records become clips. Then, the clips become commentary. Then, the commentary becomes a market. And once there's a market, the next step is dramatization. In January of 2020, Shanann's family publicly denounced a Lifetime production based on the murders. They said they were not consulted. They said they were not receiving money from it. They warned it could reignite conspiracy theories and online harassment. That response was not about the verdict. It was about the cost of being forced to relive the same week as entertainment. A few months later, the case entered a different kind of spotlight. On September 30th, 2020, Netflix released American Murder: The Family Next Door. The documentary did not need reenactments to create emotional force. It used archival material. It used social media posts. It used text messages. It used law enforcement recordings. It used home video footage. That format changed how people experienced the story. A courtroom shows evidence to prove guilt. This documentary showed ordinary life, so viewers felt the loss before they understood the full truth. That approach created empathy. It also created a new wave. It pulled millions of new eyes into the archive. And once new eyes arrive, the archive restarts. People search for the files. People search for the interviews. People search for the pages that a trial would have presented in order. They find the same records again. They rewatch the porch interview again. They rewatch the body camera footage again. They treat the case like a puzzle, even though the legal ending is final. This is the modern problem. A plea deal cannot solve. A plea can lock a sentence permanently. A plea cannot lock the narrative. Once the narrative becomes a public archive, it becomes renewable. It can be revived by a documentary release. It can be revived by a dramatization. It can be revived by a new document dump. It can be revived by someone discovering the case for the first time years later. The legal system recognizes this, which is why the Weld County District Attorney's Office published a formal process for requesting access to released Watts case materials. The case created so much demand that the office had to build a public pipeline for a single file. That is not normal. That is what notoriety does. And when notoriety takes over, The most dangerous thing is not curiosity. The most dangerous thing is certainty. Certainty turns fragments into accusations. Certainty turns silence into proof. Certainty turns grief into a target. That is why the family's warning about harassment mattered. Because the archive does not only preserve evidence, it also preserves vulnerability. It preserves private messages. It preserves a family's last days as permanent exhibits. It invites strangers to judge a marriage as if judgment can explain annihilation. So, the final chapter of this case is not written by the judge. It is written by the audience. The audience decides whether the archive is a warning about deception, secrecy, and collapse of empathy, or whether the archive is just another product to consume, clip, and repeat until the victims disappear behind the noise. By the time the files began circulating, the tragedy was no longer only a closed criminal case. It was becoming an ongoing public product built out of documents, recordings, and retellings that could be restarted at any time. For the legal system, the core work was already finished. Christopher Watts had pleaded guilty, and the judge had imposed life without parole. The state had done what the law can do. It had removed him from society permanently. But for Shanann's family, the end of the prosecution did not mean the end of risk. The risk changed shape. The risk became the possibility that the killer could still benefit from attention, even indirectly, through interviews, media deals, or future projects built around his name. That is why the family moved into civil court. They filed a wrongful death lawsuit, not because they believed a prison cell could produce money, but because civil court can place a permanent legal claim on any future value tied to the story. A civil judgment functions like a lock-on profit. It does not heal grief. It does not restore a future, but it can block a murderer from turning notoriety into leverage. In December of 2019, the civil case ended in a judgment that required Watts to pay $6 million to Shanann's parents. The number was symbolic and legal at the same time. Symbolic, because no amount can equal what was taken. Legal, because the debt follows him, and any future income connected to the case can be pulled into that judgment. This was one of the few places where the family could still draw a boundary. They could not stop people from watching. They could not stop people from arguing. They could not stop the internet from turning pain into content. But they could attempt to stop the killer from benefiting if anyone ever tried to put a contract in front of him. At the same time, the case's public afterlife was accelerating. The reason was simple. A plea deal ended the trial. A trial would have forced a single narrative into open court, with evidence presented in order and testimony shaping a complete arc. The plea removed that structure. So, the public went looking for the missing arc inside the archive. That pressure exploded into view on November 21st, 2018. When the Weld County District Attorney's Office released more than 2,000 pages of investigative documents. The release did not feel like routine transparency. It felt like a substitute for a trial. It gave the public access to interview summaries, investigative notes, and pieces of private communication. It also changed the cultural behavior around the case. People stopped consuming the story in one linear form. They began consuming it as fragments. They screenshot pages. They clipped paragraphs. They posted excerpts. They turned raw record into narrative and narrative into commentary and commentary into certainty. Once that happens, the case does not settle. It becomes renewable. A new audience can discover it years later, open the same documents, and experience the same shock as if it is happening now. That is why the system eventually published a formal process to handle requests for released Watts case materials. The district attorney's office had to turn the case into a managed pipeline because the demand did not fade. It kept arriving as forms, emails, and requests for the same file, again and again, from around the world. But the archive did not belong to one office. That is another detail most people do not understand. Different pieces of the record belong to different custodians. The District Attorney's Office can release what it holds. The Colorado Bureau of Investigation holds other parts. So when people demanded the prison interview record later, they were directed away from the district attorney and toward the state agency that created the report. This division of custodianship matters because it shows how a case becomes a network of records, not a single file. And in a notorious case, every node in that network becomes a target for public demand. Then, in March of 2019, the archive expanded in the most dangerous way. Not through paperwork, through voice. A written document creates distance. Audio creates proximity. On March 7th, 2019, materials tied to the February 18th prison interview were released, including a redacted report and audio that drew intense public attention. Investigators had conducted that interview after sentencing, when bargaining was irrelevant, and when the only remaining goal was to close the record and clarify details. The report documented that a Colorado Bureau of Investigation agent, a Federal Bureau of Investigation agent, and a Frederick police detective traveled to the Wisconsin prison to interview Watts. The public did not experience it as a record closure interview. The public experienced it as a new episode, and that is the core problem of a case that becomes an archive. A prison interview is not entertainment, but once it is released, it can be consumed like entertainment because the internet treats every new file as content. The release gave the killer presence again. It placed his words back into circulation. It turned the end of the legal case into the beginning of another cultural loop. Then the case entered the phase that turns notoriety into industry. Dramatization. In January of 2020, Shanann's family publicly objected to a Lifetime movie based on the murders. They said they were not consulted, they said they were not receiving money, and they warned that the production could reignite harassment and conspiracy theories. Their objection revealed the brutal asymmetry of the true crime marketplace. The family lives with the loss. The market lives off the story. The market does not need consent. The market only needs attention. Later that same year, the case reached an even larger audience through Netflix. On September 30th, 2020, Netflix released American Murder: The Family Next Door. The documentary used raw, first-hand materials, including home videos, social media, text messages, and law enforcement recordings. That format intensified the emotional impact because it did not rely on actors to recreate grief. It relied on the family's own digital life. For many viewers, it created empathy. For survivors, it also created a new wave. A wave means new audiences. New audiences mean renewed demand for files. Renewed demand means the archive is opened again. That is how an old case becomes present again. A release date functions like a trigger. A documentary functions like a restart button. And the restart comes with a cost. Every restart invites new commentary and new judgment from people who were never there. Every restart invites new certainty built out of fragments. Every restart creates a new round of people who believe they can solve motive by analyzing messages. But motive is not a puzzle that becomes clean when enough strangers stare at it. Motive is often cord small, selfish, and ugly. A fantasy of escape. A refusal to confront conflict honestly. A collapse of empathy. The archive does not always satisfy the public's hunger for explanation, because the simplest explanations feel too thin to carry the weight of the crime. So, the public often reaches for complexity. Complexity feels safer than simplicity. Complexity suggests a hidden plan. Complexity suggests a hidden partner. Complexity suggests there must be more than what the record proves. That instinct fuels conspiracy, and conspiracy fuels harassment. And harassment becomes another layer of harm added on top of the original violence. This is why the family civil lawsuit matters in the story's afterlife. The civil judgment is one of the few tools left that aims in the correct direction. It aims at profit. It aims at the idea that attention can be monetized. It aims at preventing the killer from ever gaining financially from the narrative built around his name. At the same time, the corrections system was managing a different reality. Notoriety creates security risk inside prisons. In December of 2018, Wisconsin authorities confirmed that Watts was being held at Dodge Correctional Institution in Waupun. The transfer placed distance between the crime scene and the incarceration. It did not place distance between the case and the public. The public could not visit the prison, but it did not need to. The public had the archive. The public had the footage. The public had the documents. The public had the interviews. That is the modern shape of a case like this. The law delivered finality. The culture delivered renewal. The family tried to draw boundaries through civil court. The system tried to manage demand through formal records processes. The market tried to monetize the narrative through dramatization and documentary. And the archive remained open, waiting for the next audience to arrive and restart the story again. A courtroom can close a case. A prison can hold a man forever. But an archive can keep the tragedy alive indefinitely, unless the audience chooses to stop feeding it. After the guilty plea, the legal outcome stopped changing, but the administrative life of the case accelerated, because the public did not only want an ending. The public wanted possession. People wanted the paperwork. People wanted the recordings. People wanted the same material a jury would have seen, but without the order and discipline of a trial. That demand forced the system to do something that is rare for a local homicide case. It forced the creation of a public access workflow. The content reference away site, Scrapplaw, Index 0 published a dedicated page to streamline requests related to the case. The page laid out a step-by-step process. A requester had to download a form, complete it, and submit it for review. If the request was approved, the requester would be granted access to the files. The page also included a blunt warning that the files were very large, which is the kind of sentence that sounds ordinary until you understand what it means in practice. It means the case file had become so massive and demand had become so global that bandwidth and storage became part of the story. The office even offered physical media, a USB drive option for an additional cost, because the archive had outgrown casual sharing. Then the page drew another boundary that most people outside the system do not think about: custodianship. The archive was not a single object owned by a single office. Different agencies held different pieces. And for the most requested pieces, The public had to go to the right custodian. The district attorney's office stated that it was not the custodian for the February 18, 2019 prison interview materials, and it directed people to request those records separately through the content reference OE Site Pawn 1. That detail matters because it explains why the story never settles into one definitive public packet. There is always another gate, and always another request process, and always another new release that feels like a new episode. A trial would have forced the state to present evidence in order. A plea deal ended the courtroom narrative quickly, and the public responded by turning the archive into the main stage. Once the archive became the stage, the next conflict was predictable. Oh, profit! In a case like this, attention becomes a currency, and currency attracts people who want to turn tragedy into an asset. Families understood that risk immediately, which is why they moved into civil court almost as soon as the criminal court finished. On November 19, 2018, the same day sentencing was imposed, Shanann's parents filed a wrongful death lawsuit against content reference, Wordai 2, Index Court 2. The stated purposes included funeral expenses, economic losses, and compensation for ongoing emotional distress. But there was another purpose that mattered just as much. The lawsuit was also framed as a way to prevent future profit, including profit through projects tied to the story. It was a legal attempt to place a permanent claim on any money that might ever be generated from this crime, because the family could not control what the internet would do, but it could try to control what the killer could gain. That civil effort eventually became a formal number. On December 16, 2019, reporting described a civil resolution requiring Watts to pay $6 million to Shanann's parents. Quotent reference Barry Isaac 3 and quotent reference Bea cited 4. No one believed a prison sentence could produce that money. The practical point was not cash in hand. The practical point was a recorded liability that follows him, so that any future income tied to the case can be pulled into the judgment. That is what civil court can do when criminal court is already finished. It cannot change the past. It can reduce incentives for exploitation. While civil court was trying to close off profit, corrections officials were trying to close off a different risk: security. High-profile inmates create problems inside prisons because notoriety turns a person into a target. In December of 2018, the grid content reference O equated 5 Kansas to Grad City, and that Watts had been transferred on December 3rd to Das Traj Deis, index equals Dutch Trust, content reference O equated 7, index equals 7. The reporting described the move as being for safety reasons, and it explained the transfer under the Interstate Corrections Compact framework. That move created distance between the case and the place where it happened. It did not create distance between the case and the public. The public did not need proximity to keep watching. The public had the archive. The public had the porch interview. The public had the body camera footage. The public had the document releases. And once the case is an archive, distance becomes irrelevant, because the story can be reopened from anywhere, at any time, by anyone. That is why the next major wave arrived through a record that was never designed for entertainment. Follow-up prison interview. The official summary states that the interview was conducted by the Colorado Bureau of Investigation on February 18, 2019. And that it was released on March 7, 2019. The document was not a new prosecution tool. The legal outcome was fixed. It was record closure. It was an attempt to document, clarify, and preserve a fuller account after sentencing, when negotiation was irrelevant. But once the report and audio entered public circulation, It was absorbed by the same machine that consumes every infamous case. It became content. It became a new round of headlines. It became a new reason to rewatch the old footage and reinterpret earlier moments. It became another fuel source for people who treat a closed case as a puzzle. This is where the modern afterlife of the case becomes clear. A courtroom ending is final. An archive ending is renewable. A courtroom produces closure. An archive produces reopening. And the system, even when it tries to act responsibly, cannot prevent reopening once the files exist and the public can request them. The district attorney's request page proves that the case reaches scale where public access became a managed service. The civil judgment proves that the family saw the danger of monetization and tried to block it. The transfer to Wisconsin proves that notoriety changes how incarceration is managed. The March 2019 release proves that even post-sentence documentation can restart the cultural life of the case. Then the public takes over, because the public always takes over when a case becomes famous enough. People choose what they watch. People choose what they share. We bore come day. People choose what they clip and repost. People choose whether private messages are treated as evidence of danger or as entertainment. People choose whether the victims remain human beings or become characters inside an endless loop. That choice is the real ending, because it is the only ending that can stop the story from restarting. The law already did what it could. The law imposed permanent confinement. The law created records. The law allowed access under rules and custodianship. What remains is the cultural decision about how those records are used. If they are used with discipline, they can teach the public how modern investigations verify truth and how deception collapses under objective timelines. If they are used without discipline, they become raw material for speculation, harassment, and profit. That is the final contradiction of this case. The public says it wants truth. The internet often wants stimulation. A records request can be about accountability. A records request can also be about appetite. And once appetite is fed, the archive is never empty, because there is always another form to submit, another file to open, and another wave of attention that brings the story back into the present. There is a moment when a tragedy stops being a case and becomes a service. Not a service in the human sense, but a service in the administrative sense, where the record is packaged, priced, and processed. In the Watts case, that moment is visible in the way the file was turned into a managed workflow. The district attorney's office published a dedicated process for access to released materials. It was not written like a news story. It was written like instructions. Download the form. Submit the request. Wait for approval, then receive access. Even the warning is procedural. The files are very large. If you do not have high-speed internet, request physical media. A USB drive, a set cost. That detail is easy to skim past, but it changes the moral atmosphere of the story. A family was erased. Then the record of that erasure became something that could be distributed on a flash drive. It is not wrong that records can be accessed. Transparency matters. Public accountability matters. But this is where the modern age introduces a new kind of violence. A murder case becomes a commodity of attention. A record becomes a product of demand. A form becomes a purchase order for someone else's worst week. Then another boundary appears. The boundary that most people do not understand until they hit it. Custodianship. The case file does not belong to one office. Different agencies hold different pieces. and the most sought-after pieces are often held by the agencies that created them. That is why the district attorney's office explicitly said it was not the custodian for the February 2019 prison interview materials. If you wanted that record, you had to request it from the Colorado Bureau of Investigation. This matters because it keeps the story in motion. A closed case should settle, but the public does not experience closure as a sentence. The public experiences closure as content. So, the public keeps pushing on the archive. When one door says no, the public walks to the next door. When one office says, "This is not ours," the public files another request elsewhere. The case becomes a network of gates, and every gate creates the illusion that something new is still waiting behind it. That is exactly what happened after the guilty plea. On November 21st, 2018, more than 2,000 pages of investigative documents were released. For many people, that release became the substitute for a trial. Not because it was orderly, it was not. Not because it was complete, it was not. Because it was a volume of raw material. And raw material is what the internet knows how to turn into narrative. The record did what a courtroom would have done in a single arc, but it did it without a single arc. It scattered the story into pages. It invited people to assemble their own version. And once people assemble their own version, they stop listening to the one version that matters, the verified version. Then, months later, the archive grew again and reactivated everything. The follow-up prison interview was conducted on February 18th, 2019 in Wisconsin, after sentencing when there was nothing left to negotiate. The report documents who was there and why they went: a state agent, a federal agent, and a local detective. The purpose was record closure and clarification, including questions about other alleged affairs and the claims that kept circulating. Then, on March 7th, 2019, the interview report was released publicly, and audio and transcript coverage followed. This was not a new investigation. This was not a new prosecution, but the public consumed it like an episode. Because audio changes the experience of a case. A document can be read as information. A voice is experienced as presence. Presence creates intimacy. Intimacy creates the illusion of knowledge, and that illusion makes people reckless. They begin to treat late statements as if they were trial testimony. They treat secondhand releases as if they were cross-examined. They treat a killer's narrative as if it were a stable source. It is not. A convicted murderer can still lie. A convicted murderer can still reshape. A convicted murderer can still seek control. And sometimes control is the only currency left. So the archive creates a paradox. The more truth the system releases, the more content the public has to circulate. The more the public circulates, the more the story returns. The more the story returns, the more the families are forced to relive it. That is why this case became a machine. It began as a missing family report, triggered by a friend who recognized that silence was not normal. That urgency brought police to the house for a welfare check. Video and records began to form immediately. Once video and records exist, the case stops being only a memory. It becomes replayable. Then, the plea deal ended the trial. The trial is the one structure that forces evidence into order and forces claims into testing. Without that structure, the archive became the main stage, and the stage always attracts an audience. So, the public ending of this case is not the sentence. The public ending is the workflow, the forms, the approvals, the file sizes, the custodians, the USB fee, the release dates that restart attention. It is the transformation of a family's last days into a permanent distributable record that can be opened again and again by anyone who wants to feel close to horror. The legal system already delivered the only ending it can deliver. Life without parole, no future freedom, a closed door. But the archive created a different ending, a renewable ending. And as long as the archive remains easy to access, and as long as attention remains profitable, the case will keep returning, because the public will keep treating access as understanding, even when access is only exposure, and exposure is not the same thing as truth. In most homicide cases, the file exists for the court and the parties, and the public sees only the outline through hearings and short press statements. In the Watts case, the file turned into an intake system. The Weld County District Attorney's Office published a dedicated access process that treated the Watts materials like a managed distribution package, not like a typical local case file. The process required a written request on a specific form under Colorado's open records and criminal justice records statutes. The form itself is blunt. It asks for a name, an agency, contact information, and the stated purpose of the request. It also pre-fills the identifying spine of the case. Because the file is so famous, it does not need explanation. It lists the case number as 18 CR 2003, and it lists the defendant as Christopher Watts. That detail matters because it shows how the case stopping something a prosecutor's office handled informally. It became a standardized pipeline. The office also warned that the files are very large and that people without high-speed internet could request physical media, including a USB flash drive, for an additional fee. When a case reaches the point where a county office has to offer the record on a paid USB option, you are no longer dealing only with justice. You are dealing with demand. And demand changes behavior. Demand makes people treat access as ownership. Demand makes people treat paperwork as entertainment. Demand makes people treat a family's last days as a library they have the right to browse. Then the system exposes another reality that the public rarely sees. Custodianship. The district attorney's office made it explicit that it is not the custodian for the February 18, 2019 prison interview materials, and it directed requesters to the Colorado Bureau of Investigation for that category of record. This creates a case that never feels finished in the public imagination. There is always another door to knock on. There is always another agency to file with. There is always another form, and every form creates the illusion that the next release will finally provide the missing why. That is the trap of an archive. A trial forces one ordered narrative through testimony. A plea ends the courtroom narrative quickly. The public then tries to rebuild the missing trial from fragments. And fragments never produce closure, only more appetite. The records workflow also shows something else. When a government has enough demand, it moves the request process into a portal. Weld County maintains an online records request portal where a requester can submit a new core request through a public interface. This is the same transformation in a different shape. A crime becomes a case becomes a sentence. A sentence becomes an archive, and an archive becomes a service. This is why the story does not settle even after life without parole. It cannot settle while the archive is easy to request, easy to download, and easy to redistribute. Every new audience finds the case. They discover there was no trial. They go looking for the documents. They locate the request process. They file for access. They open the file. And the story restarts again, not as a legal event, but as a cultural event. The system can confine a man forever. The system cannot confine the record. Once the record is in circulation, the case becomes renewable. and renewal is the opposite of closure. At a certain scale, a criminal case stops being handled like a case and starts being handled like a queue. It becomes forms, intake, approvals, fees, and file delivery. That is not because the system wants to commercialize tragedy. It is because the demand becomes so relentless that the only way to respond is to standardize. In Weld County, the district attorney's office published a dedicated page titled Information on Watt's case. It does not read like a press release. It reads like instructions for access. It tells requesters the files are very large. It tells them that if they do not have high-speed internet, they can request physical media. It even states an additional cost for a USB flash drive when a county office has to quote an $85 fee just to move a case file through the public pipeline. The story has already left the courtroom. The crime is no longer only a tragedy. The record of the tragedy has become a system that must be managed. The next step in that system is paperwork. The request form is a Criminal Justice Records Act request form built specifically for this case. It is not a generic template. It is a document that treats this file as unique. It names the defendant. It references the statutes. It asks for the purpose of the request. It turns the act of reading a case file into a formal transaction between a member of the public and a government custodian. That is what the modern archive looks like. It is not only a library. It is an administrative gate with a form and a workflow. Then there is the portal. Weld County maintains an online public records request portal where requesters can submit Colorado Open Records Act requests through a public interface. This creates the same reality in a different shape. A tragedy becomes a case becomes a sentence becomes an archive. An archive becomes a service. Once the archive is a service, the case never feels finished to the public. Because a service implies continuation. A service implies there is always a next step. A service implies there is always more. That is why custodianship matters so much. The district attorney's office also drew a boundary on that same page. It stated that it was not the custodian of the February 18th, 2019 prison interview materials. It directed requesters to the Colorado Bureau of Investigation for those records. This is a procedural detail, but it has cultural consequences. It means there is not one final packet. There is not one definitive download. There is a network of records across agencies. There are multiple doors. There are multiple forms. There are multiple custodians. And every new door creates the illusion that the next door will contain the missing explanation. That illusion keeps the story alive. In a normal case, the public watches the court process, reads a few articles, and moves on. In this case, the public learned there was no trial. The plea ended the courtroom narrative quickly. So the public tried to rebuild the missing trial from the archive. And an archive cannot provide closure the way a trial can. A trial forces order. A trial forces testing. A trial forces claims to be challenged in open court. An archive gives access without order. It gives fragments. It gives pages that can be read out of sequence. It gives interview summaries that can be misinterpreted as final truth. It gives messages that can be judged by strangers who never lived inside that home. Access without order creates appetite, not closure. That appetite has a rhythm. A new audience discovers the case. That audience learns there was no trial. That audience goes looking for documents. That audience finds the request page. That audience files the form. That audience receives files. Then the audience becomes an amplifier. Pages become screenshots. Screenshots become captions. Captions become certainty. Certainty becomes accusation. Accusation becomes content. Content becomes community. Community becomes pressure. Pressure becomes more requests. The archive becomes a machine that feeds itself. This is where the story becomes uncomfortable in a different way. The original violence ended lives. The archive does not end. The archive keeps circulating the victim's private moments as public artifacts. The archive keeps circulating the killer's performance, the interviews, the footage, and the later prison statements, even though the censor was designed to remove him from the world. A prison can confine a person. A prison cannot confine a record. Once the record is distributable, distance becomes irrelevant. It does not matter that he was moved out of Colorado. It does not matter that he sits behind concrete and steel. The public does not need proximity to keep watching. The public needs access. And access is now processed through a form, a portal, and a delivery system. This is the administrative life of notoriety. It turns tragedy into an object that can be requested. It turns grief into a file-size warning. It turns a family's last days into a data transfer problem. It is not personal. It is bureaucratic. But bureaucracy is how the system survives pressure, and the pressure never stopped. That is why the district attorney's office had to build a page that answers the same questions again and again. That is why the office had to explain file size. That is why the office had to offer a USB option. That is why the office had to clarify who holds what. The case became too large to be handled by ordinary conversation. It had to be handled like volume. Once volume takes over, human dignity becomes harder to protect, not because officials do not care, because the public pipeline does not have empathy built into it. A request is processed, a file is delivered, a record is copied, a record is reposted, and the victims are forced back into public view again, over and over. This is the final transformation of a modern true crime case. The legal ending is final. The cultural ending is renewable. The legal ending is a sentence. The cultural ending is a workflow. The sentence closes a door. The workflow opens a portal, and a portal invites the world to keep entering. That is why this case continues to feel present years after August 2018. It continues to feel present because the archive is designed to be reopened. It continues to feel present because every new requester becomes a new narrator. It continues to feel present because every form filed is another confirmation that the story is still being fed. The system can only do a few things. It can prosecute. It can sentence. It can manage records access according to law. It can set custodianship boundaries. It can charge a fee for physical media when files are too large. It cannot stop the public from treating access as ownership. It cannot stop the internet from turning documents into content. It cannot stop the market from rewarding retelling. So the real ending is not written by the judge. The real ending is written by the audience. The audience decides whether a records portal is used to understand how deception collapses under verification, or whether it is used to satisfy appetite, or whether it is used to build theories that can never be proven and that keep injuring the living. Because In the era of public portals and distributable archives, closure is not automatic. Closure is a choice. And in this case, the archive made reopening effortless.